Good morning and welcome to our webinar on how to audit your intellectual property. This particular webinar is dedicated to the World Intellectual Property Day happening tomorrow. We have this time specialists from all our Baltic offices, and the topics we are covering today range from issues on how to audit your IP, how to protect it. We will look at the copyright challenges posed by the rapid developments in AI, and also look at certain issues that relate to the use of open source components in your computer programs. So a couple of organizational notes. If anyone wishes to present questions to our speakers today, please use the Q&A function available in the Teams application. I strongly suggest to use it immediately during the presentations. Today's webinar will be recorded, and the recording will later on be made available to all those who registered their participation. And yeah, from my side, as we all know, intellectual property affects almost all aspects of our everyday lives, and for businesses it's especially crucial to be on top of protecting and manage their intellectual property. So I'm very excited to hear what our presenters, my dear colleagues, have for us today. Our first speaker today is Helery from Sorainen Estonia office, and she will talk about how to audit IP and the legal due diligence process. So Helery, floor is yours.
Thank you, Mihkel, and hi everyone. So indeed, today I am going to talk about the introduction to IP audit and legal due diligence process. So basically, I'm just going to give you a quick overview of the two systematic approaches that you can use to either manage or evaluate your IP assets. And before moving on to answer the question how, let's talk about the question why you should care about managing your IP assets. Well, to that I would say whether you're a software startup, already established retail company, or an independent graphic designer, IP in some sort of format is probably part of your business. And the proper IP asset management as such really helps you to ensure and protect your investments into your brand, into your business in general, but it also helps you to attract investments and increase basically the value of your company, of your brand, of your creation, etc. So it is really something that is it should be like part of the mentality how you operate as a business, and not just like a long, lengthy legal process that is probably boring and should not be something that you want to be bothered with. But it really is something to consider as it's part of your this like overall package as a business. And moving on. So what is actually an IP audit, and what does it mean as an approach or as a tool to manage your IP assets? Well, to put it really simply, it is basically a systematic overview or review of the intellectual property assets owned, used, or acquired by a company. And what we do during the IP audit is that we review the company's IP assets, related agreements, relevant policies, and compliance procedures. So it is really asking, like, tracking down all the creative process and everything that is IP related that you own, use, or acquire, and ask the questions like why, how, and what is the procedure, what are the documents, etc., surrounding this. And just moving on. Now, when you think about the situations when the question of a need for an IP audit would arise, like where would you need it, why would you need it? So there are very different cases for IP audit as such. It can arise when developing or reviewing business strategy, before attracting investments, before transactions, any kind of like either attracting investments, mergers, etc. When seeking other business-related opportunities, when preparing for license agreements, and when preparing for legal disputes. So you can see that there are very different types of situations where you could actually need an IP audit. And actually, just before this webinar, I was having a chat with my colleague in the kitchen, and I was talking about the topic I was going to present today. And she said, like, just the other day, a client turned to her and said, like, I wish someone would take a look at all of our documents and say that it is okay. And this is basically the service that we offer. And this is something that we do with IP audits. Now, more often than not, everything is not okay, but don't worry, we are here to help. There are also solutions that you can then acquire if we detect any kind of problems. So let's move to the process of IP audit. So what would be the necessary steps, what we conduct during this sort of like overview of your documents to detect whether everything is okay or whether there are some sort of issues that should be tackled. So first, we basically start identifying and mapping IP assets and collecting necessary documents for this. Now, step 2 is that we take a look at these documents and try to detect what is the ownership of the IP, what is the status, what are the regulations in relation to that. So basically how you have dealt with the IP asset that you at least think you have. And step 3 is detecting any like sort of problems furthermore, whether there is a trademark that is unregistered, the domain name, you name it. And this is now the IP audit process in more detail. So basically, just going through the steps that are necessary to really take a stance on how your IP assets are managed. Now, quite common situations are where you think that a software, like for example, you're a startup, you think that you have invented a perfect software, and this is like the essence of your business. But then when you start to track down the actual process, how some sort of software is acquired, etc., then it might happen that you realize that actually not all the license agreements are in place. I don't know, something has been developed by an independent contractor, etc. So you can come to a realization that there is a deficiency in the process and something should be done. So basically, that is how we approach this matter. First, we create an audit plan, we create a schedule, and then we start collecting all the documents. So it really means mapping down all the materials that you can possibly have and find about the business, I don't know, the software, the slides, the pictures you use. So this is basically the whole package of what can be an IP asset for a company, for a brand. And then we check for, as you can see, it's now the second step, and this really goes to more elaborate different steps. Under this, we check whether you have all the registrations done, what is the situation with the agreements. You have maybe developed a perfect brand, the name, the logo, but actually somewhere down the line you have forgotten to register, for example. So it can really come and bite you at one point if this problem has not been dealt with, if it really is like a key aspect of your whole branding, for example. Then after we have gathered all these documents, taken a look at them, we start to really identify the potential deficiencies. And then after we have gathered all of this, the product that is produced is an audit report. So basically, what I want to say here is also that we are not only during this process telling like what is wrong, what should and where you have failed, but we are also here to help you, which means that as a product with the audit report, we also determine everything that could be done in order to better protect your IP assets. So whether it is proposing new license agreements, renewing some agreements, or making a trademark registration plan, all of this is part of the aftermath. So, and that's basically a tool and the procedure that could be used in order to better protect your IP assets. Now, talking about the different sources, how we try to detect potential issues. It is a bit related to it is directly related to the process map that I just showed, but this sheet would probably help you to understand all the different sources and all the different ways where this IP assets and regulations and issues could actually be in. Some of the things that you maybe not even think about. So there is one portion of all the registrations and applications for rights. So basically all the IP rights that should be registered in order to have protection. Now, I am really going to give you just a brief overview of all of this. My colleagues later on will go into more details into the different types of IP assets and rights that you could protect or you could have. But basically, how we detect the potential issues or confirm that you don't have any issues is starting with all the registrations. Then another big portion is really agreements. And here, as I already brought you an example of independent contractor, software developer who might have done actually a really big portion of your essential software. So checking that the license agreement and the terms of the licenses are really in place and enough for you to take advantage of the software that you would actually like to use. So yeah, it is all the licensing agreements, employment agreements, different type of non-disclosure agreements. So basically the whole baggage of agreements that you might have had with other parties. And I think this part is really important in a sense that we might not always immediately realize how what IP I have used and how it has been transferred, or if it hasn't been transferred. We tend to think maybe that if a service has been provided, I have paid for something, or an employee has done something for me, then surely it must be fine, like the regulation behind it. But unfortunately, it is not always the case. As my colleagues will probably tell you afterwards, there's different regulation for moral and proprietary rights of IP, and these should be regulated differently in agreements, etc. So there are really nuances that that could be looked at, and where the problem may lie that you might not immediately realize. And now the third category is all the other IP-related documents, litigation proceedings, letters of claim. So maybe it has been so that there has been raised a claim towards any of the IP that you're using, or there's some other sort of dispute. So this is also a portion of documents to be looked at in order to determine how good is the state of the management of your IP assets. Now, let's move on to the other sort of like a approach or a tool that comes into play when we are talking about the management of IP assets. I'm now talking about IP in legal due diligence process. So let's first start maybe just quickly explaining what is this legal due diligence process. In essence, it's actually an audit made for a specific purpose. So in a simple way, it erases in relation to any sort of like a transaction, whether it be accusation, acquisition, merger, attracting investments, etc. Where essentially what is like the focus of the exercise is to answer to the buyer or to the investor to the question like, are there any reasons why I should not buy something or not invest into something? So basically doing like the homework before I put my money into somewhere. I mean, there can be different purposes for conducting the legal due diligence, but more often it comes into play in this type of situations when there's like a target, someone is trying to either like do some sort of transaction into it. So during this process, again, we do like audit to detect if everything is in right order and if there are any risks that should be actually taken into account when going into the transaction for real. So again, this process, I mean, legal due diligence in general can be and most often is about like different areas in your business, like a company aspect, employment aspect. IP is just one part of it, but increasingly more important part actually, because IP has such a great value. Think about I don't know, any investment any software company, any brand, Amazon, Google, you name it, like IP is actually a key part of their value. So it is really something that investors more and more are concerned with, and so should be the businesses themselves. And this process again starts with the question like, what IP does the company have? And to put this into legal framework for us, for lawyers, for example, we first have tried to understand what is your business, what is that you do, what is the services that you provide, to understand like what sort of IP you probably have, what you should have, and in that way put this questionnaire, so to say, or this audit into legal framework to fit into your business model, and through this understand what is actually essential for you. And then we go on and see if this IP can be protected. Has it been protected? So relating back to my sections of registered IP assets. And then we again check all the assignments, licenses in place, are they being complied with, etc. So basically doing like the audit version for a specific purpose then. And if you now think, what will we do with all the answers that we have received during this legal due diligence process or this audit, is that we basically end up with findings. So some sort of like formulated conclusions, what we have seen, where we have detected any sort of risks or problems, what could be done better, and then we formulate them into findings. And based on the findings, we also make some sort of recommendations, either just for the target or the business that was audited, or for the purchase agreement that is going to happen later on, like as a result of this legal due diligence. So what do I mean by the recommendations or the list of findings? It may be that some findings that we have are related to the aspects that should be dealt with before the transaction is going to take place. So the conditions precedent. For example, we detect that there are not all the license agreements in place. Some license agreements are maybe not in their entirety, so they should be maybe leveled up. So basically, these are all the things that should be done prior to the transaction. Now, the other category of the recommendations based on the findings that we use in legal due diligence process is the warranties. So basically, when we conduct a situation where there is like a risk, or where we have asked the question from the target, like, are you aware of any legal disputes or any risks that are in place in relation to your IP assets? The answer more often is no, not that we are aware of. So in these cases, we put in the confirmation like that the target confirms that indeed we're not aware of any liabilities, and in case there arise some issues afterwards, then we can relate back to the confirmation. And lastly, all the issues that we have detected that are related to the steps that should be done after the transaction, so conditions subsequent, which means basically all the issues that are worth to be considering, but they are not maybe so essential or crucial in relation to the purchase or the transaction right away. So quite often, for example, trademark registration, it is quite common to realize that the trademark that you use is actually not registered, but it's a quite lengthy process. So afterwards, it is worth thinking about whether I don't know, there are areas, there are countries, territories that you would actually want to register a trademark and basically build a policy for your trademark in general. So yeah, actually this was this IP audit and legal due diligence process in a nutshell, what they are and where you can use them, how you can use them. And yeah, I'm gonna give you now floor to Mihkel back to introduce all the other presenters. Thank you.
Thank you, Helery. And we are moving straight on to our next topic and next speaker. We have Krišjānis from our Latvian office speaking about how to make sure that your intellectual property assets are protected. So Krišjānis, floor is yours.
Yes, thank you, Mihkel. Indeed, today I will speak about on topic how to make sure that your intellectual property assets are protected. My presentation will deal with the industrial intellectual property, about which I will give a short introduction a bit later. Then, due to the limited time amount, I won't be able to go through all IP objects in detail. And that's why I have chosen to speak more in detail about the most popular industrial property object, which is trademarks. And then in the end, I will also discuss some nuances regarding domain protection. Generally, intellectual property is divided into two branches. The first one deals with the copyrights and related rights. My colleagues later will discuss some details regarding copyrights and also their interplay with AI. And the other branch is industrial property, which covers trademarks. Trademarks are commonly and in public probably known more as logos or brands. And in essence, these are the signs that are used to distinguish one person's goods and services from another person's goods and services. Then there are also designs, which are basically the external appearances of products, also their packaging, and such appearances can be, for example, a specific shape. And if the first two IP objects deal with kind of this external appearance and branding, then patents, on the other hand, protect the product itself, the invention. And in order to be protected, it must meet certain criteria. And then there are also geographical indications, which in practice appear less often, but these are basically the signs that are used to show that a specific product is from a specific geographical region. It encompasses specific reputation and quality requirements. And for example, the most popular one would be probably champagne. And there are also other IP objects which do not belong to any of those two branches, such as domain names, which are symbols separated by the dot and used to access specific websites. And there are also other IP objects such as trade secrets or plans, but I will not discuss them today. The main thing that needs to be remembered when speaking about protection of industrial property and protection of IP rights overall is the fact that IP rights are protected separately from material objects. So IP rights are transferred only in the case when it is explicitly agreed upon in the contract. Then another thing regarding industrial property is the fact that protection is harmonized worldwide due to different treaties. In other words, countries have adopted unified minimum standards for protection of these objects due to the fact that they have ratified conventions and treaties that govern these kind of protections. And the main difference between industrial property and protection of copyrights is the fact that copyrights are granted automatically from the moment of creation of the work, while for industrial property, this protection is acquired through registration. And as you can see, for some objects, specifically for trademarks and designs, this protection can be acquired also without registration. However, the protection is much narrower. For example, if there would be a legal dispute regarding IP infringement, the success rates would be much higher if these IP rights would be registered. And on the other hand, patents are protected only when they are registered. And the main rights that are granted by registration are these exclusive rights, which permits to use the specific IP object and to prevent others, prohibit others basically from using it. In other words, these are kind of these monopoly rights over specific IP object. In the case of trademarks, the protection is limited to specific goods and specific goods and services in accordance with the NIS classification. While for designs and patents, this classification is purely administrative and does not in any way affect the scope of protection. So one of the most essential principles of protection of industrial intellectual property is the principle of territoriality. In other words, it means that a specific IP object can be protected in a specific territory. And as you can see in this slide, I have kind of indicated these three types of territorial levels where IP rights can be protected. The first one is registration in a national office. In this case, the protection is granted in one specific country. Then there is also a chance to register IP objects in the European Union. In case of trademarks and designs, it can be done through the European Union Intellectual Property Office. And the protection in this case is granted throughout the whole European Union. While in the case of patents, it is possible to submit application for this unitary patent registration in the European Patent Office. But in difference with trademarks and designs, patents are only protected in 17 member states that have ratified this Unified Patent Court Agreement. So the protection is not throughout the whole European Union. And then there is also a third mechanism how you can acquire protection internationally. It is by submitting a single application to protection in multiple countries. In the case of trademarks, this application must be based on already existing rights that are basically expanded internationally. This is not required for designs and patents, but at the same time, it must be noted that this mechanism is different from the one where rights are granted throughout the European Union, as this only offers a chance to submit a single application, which is then reviewed by different offices and the decision is taken separately. And as mentioned, I will touch upon more in details on trademarks, and I will discuss the requirements that trademarks must meet in order to be registered, and also different mechanisms how to ensure that no one else has earlier trademark rights for the registration that you want to apply. There are absolute requirements and relative requirements that must be met in order for trademark to be registered. Absolute requirements deals basically with the interests of public. There are many of them, but I have picked out 3 of them. The first one is the most popular one, and this one deals with the prohibition to register trademarks, which consist merely of information about the characteristics of the goods and services. And as an example, it would be prohibited to register award webinar for educational services, as everyone should be allowed to use this word, while it would be okay to register this word, let's say, for different goods and services, for example, coffee, beverages, if there are no other earlier rights towards this trademark. Then it's also prohibited to register trademarks which consists of general designations which have become customary in the everyday language in respect of the goods or services applied for. As an example, this could be Jeep, which is used in everyday language to describe off-road vehicles, or jacuzzi, which is used to describe hot tubs. And it is also prohibited to register trademarks which contradicts with the public order or generally accepted principles of morality. This assessment is subject to the analysis of the specific trademark office. But as an example, there was this recent case in the European Union where European Union General Court agreed with the European Union Intellectual Property Office that registration for Pablo Escobar trademark must be refused because it contradicts these principles of public order and the generally accepted principles of morality. And if first absolute ground requirements dealt with public interests, then these relative requirements deals rather with the interests of legal right holders that have already acquired maybe earlier rights for a specific trademark. There are also more of them, but I have included 2 which are the most popular ones. And firstly, it is prohibited to register a trademark which is identical or confusingly similar to earlier trademark that is registered for identical or similar goods and services. And it is also prohibited to register trademark which is confusingly similar to a well-known trademark, regardless whether this well-known trademark is used for the same goods or services or not. And the protection for well-known trademarks is wider because they have acquired a certain reputation in the eyes of consumers. And thus, consumers automatically kind of link these marks with these well-known trademarks. And in order to check whether there indeed are no prior trademark rights and proposed trademark is available for registration, it is necessary to check trademark databases. I have included 3 of them here in this slide. The one from Latvian Patent Office, one from European Intellectual Property Office, and also TMView database, which is also run by the EUPO. And in these databases, the trademarks must be searched, taking into account specific goods and services, specific territory, their verbal elements, visual elements, and other things. But besides search and trademark databases, it is also necessary to perform proper internet search and to check company registers in order to understand whether there are no unregistered trademark rights that could potentially be then later enforced against the registration. And based on the results from the trademark search and taking into account the most similar trademarks that arise from this search, the comparison between our already existing earlier trademarks and the proposed trademark must be made. And this similarity must be assessed from visual, phonetic, conceptual, and as well as from the perspective of similarity between goods and services. And all these aspects then must be taken into consideration together by evaluating the risk of consumer confusion of these specific trademarks. These factors can be different. For example, if the registration application, not yet registration, is applied for goods that are generally cheaper, then it is considered that consumers are less attentive when buying these goods. Therefore, the risk of confusion also remains higher, and there is the similarity level needs to be as low as possible. And I will also quickly go through the main protection aspects of domains. At the beginning, it also must be noted that domains are protected also by trademarks. Specifically, if there is a registered trademark, the trademark owner has the right to prohibit the registration of domain which contains this trademark. At the moment, there are over 1,500 top-level domains, and top-level domain is basically the part after the dot. For example, if there would be a domain google.com, then .com would be considered the top-level domain. And these top-level domains nowadays are issued to different organizations and institutions, and of course also to countries, as countries have their national domains, for example, .lv in Latvia, .lt in Lithuania, and .ee in Estonia. And in order to understand whether the domain is free for registration, the search must be performed in a domain database, which is who.is, which is database / kind of service. And in difference with trademarks, domains do not grant any ownership rights, but there is a right to use a domain for a specific time period, which can be then, of course, renewed, but there is no ownership right to specific domain. And the right to use these domains can be acquired by purchasing it from domain registrars, which usually also offer domain hosting services. And I have also included a few considerations that must be taken into account before domain registration. One is that it is recommended to register additional top-level domains. That's because it is to avoid a possible risk when someone registers the same word in a different top-level domain, and this is especially important in case if the business operations are planned in different jurisdictions. And as mentioned, trademarks protect domain names, but however, it is still recommended to register domain before trademark application, because there are people who are following these trademark publications and check whether this trademark is also registered for a specific domain. If it is not registered for domain, they tend to register these domains, and then they try to ask for money from a trademark owner in order to free these domains and assign them back to the trademark owners. And often this process takes a lot of resources. Therefore, often these trademark owners agree to pay this money and do not engage in complicated legal disputes, as this could potentially take more resources. And that's it from me today. Thank you for your attention, and I will be ready to answer to your questions later.
Thank you, Krišjānis. We are moving on to our next topic, copyright considerations and the use of AI. We have in that particular session 3 speakers. We have Olivia from our Estonian office, we have Linda from our Latvian office, and Raminta from our Lithuanian office. So, floor is yours.
Thank you, Mihkel. Hi, everyone. As Mihkel said, together with Linda and Raminta, we will provide a short overview of copyright regulations in Estonia, Latvia, and Lithuania. We will also share some thoughts about copyrights to AI-assisted and generated works. Copyrights protect original results in the literary, artistic, or scientific domain, which are expressed in an objective form and can be perceived and reproduced in this form either directly by means of technical devices. A work is original if it is the author's own intellectual creation. This means that the work of authorship must be created independently, not copied from another work. Objects of copyrights are, for example, written works such as articles, books, and then musical compositions, audiovisual works, illustrations, paintings, sculptures, but for example also speeches. At the same time, copyrights do not protect ideas, methods, news of the day, or facts or data. In simple terms, using a photograph taken by someone else without their permission would constitute copyright infringement, but reusing the idea behind the photo and taking a similar photo, however, would not be a copyright infringement. Computer programs are protected as literary works, meaning that the software code as it is written is protected also by copyrights. However, the ideas and principles which underlie any elements of the computer program, including those of which underlie its user interfaces, are not protected. And as Krišjānis already mentioned, copyrights arise automatically as of the creation of an original work. In Estonia and in other European Union countries, copyrights do not require registration or any other formalities. It's also not required to use the copyright symbol, a C in a circle. Copyrights consist of economic and moral rights, sometimes also referred to as proprietary and personal rights. Economic rights refer to the exclusive rights granted to authors to exploit their works for financial gain. Essentially, economic rights give the author the right to use the work, to allow or prohibit others from using it, and to receive income from the use. Economic rights include rights to reproduce, distribute, adapt, alter, perform, and display the work. Economic rights are protected during the life of the author and 17 years after his or her death. and economic rights can be freely assigned or licensed. Moral rights, on the other hand, focus on protecting the non-economic interest of creators in their works. These rights are often associated with the integrity and reputation of the creator and their connection to the work. Moral rights include the right of authorship, so the right to appear in the public as the author of a specific work, the right of the author's name, to decide whether the author's name will be designated in connection with the work or how it will be designated, but also the right of integrity of work, make or permit others to make changes to the work, and the right of additions and supplementations to the work. The authorship, author's name, honor and reputation are protected without a term. And unlike economic rights, moral rights are inseparable from the author and cannot be assigned or waived. The problem with the Estonian copyright law is that it is not always possible to differentiate economic and moral rights. So we have the economic right to alter the work, but at the same time we have the moral right to make or permit others to make changes to the work. When copyrights arise, they belong automatically to the natural person author of the works. As an exception, when an employee working under an employment contract creates a work subject to copyrights within the execution of his or her employment duties, economic rights to such works are transferred to the employer. If the work in question is a computer program or database, the economic rights remain with the employee, but the employer gets an exclusive license to exercise such rights. So this happens automatically. However, the law does not provide a regulation for moral rights in employment contracts. And as said, since moral rights allow the author to permit and prohibit making amendments to the work, it is recommended to establish a specific regulation on moral rights in employment contracts. Basically, the law provides some kind of protection, so you don't have to have regulation on intellectual property or specifically copyrights in the contracts, but it is still recommended to do so because the protection provided by the law is limited. Now, the law provides for automatic transfer only for employment contracts. In some cases, the courts have extended the regulation to contracts of services, and this might be the case when there is a permanent performance of a work function, for example, in the case of management board member agreements. However, it is always better to be safe than sorry. Therefore, we do not recommend relying on automatic transfers stemming from the law, and encourage you to always have clauses regarding intellectual property and specifically copyrights in all of the contracts under you, which one of the parties creates something for the other party. Auditing copyrights involves assessing the ownership, usage and compliance of copyrighted material. The first step is to make a list of all potentially copyrighted materials. From there on, it's important to determine who created and therefore holds copyrights to what. If a work was created in-house by an employee, the rights belong either to the employee or the company. If a work was outsourced, the rights belong either to the service provider or the company. And the answer to this question of ownership lies in the contracts that have been included. So the next step in the process is to review the contracts and analyze whether you have the right to use the copyrighted works as intended and as needed. So you have to consider are all or only specific rights assigned or licensed? Do you have the right to alter and reproduce the works? Does the contract give you exclusive or non-exclusive rights? Can the contractual partner exploit the works itself or allow them to be exploited by third parties? What is the term of the contract or the license? Can it be terminated or cancelled easily? Which territories are covered, and can the rights be further transferred or licensed? If any deficiencies are identified, then the contracts should be amended accordingly. Part of the audit process is also to check compliance, that you are not in breach of the contracts or otherwise infringing any third-party rights. If any infringements are identified, these should be addressed with proper actions to remedy the situation. It is a good practice to also document the results of the IP audit or copyright audit and the process of it, and continue working on regular updates. During audits and legal due diligence processes, the most common issues we identify in relation to copyrights are the following. So there are no agreements in place regarding copyrights. The agreements are totally silent, or the agreements are insufficient. For example, they do not cover the forms of use that you need for your business, or maybe specific territories. You have the license to use only in certain territories, but not in the others. Then no distinction is made between economic and moral rights. It's very common to see agreements establishing that all intellectual property rights are assigned. Since moral rights cannot be assigned, they remain with the author, and this in turn means that if you don't have a regulation on moral rights in the agreements, the author can later come and say that, well, you cannot use the works anymore because I have the moral rights and I prohibit you from using them. And the last one is that moral rights are licensed for an unspecified term. This is a peculiarity of the Estonian law, which says that either party may cancel a license agreement with 1 year notice. This means that in case you have a contract that provides for a license with unspecified term, the other party the contract can cancel the license at any time, and once a year has passed, again, this person can prohibit you to use or make any amendments to the work. And, or for example, demand that you use the name of the author in a specific way, or remove the name of the author from the work. Now I will give floor to my colleague Raminta, who will share some light on the differences that the regulations have compared to Estonia in Lithuania.
Thank you, Olivia, for giving me the floor. Good morning, everybody. It is my pleasure to join the esteemed colleagues on this IP webinar. And I would like to briefly touch upon certain aspects to keep in mind when you aim to protect your copyrights in Lithuania. So basically what has to be said is that a lot of requirements and the majority of rules with regards to copyright protection are established in the Lithuanian law on copyrights and related rights, and it's basically harmonized with the EU law requirements, directives, and so on. So a lot of basic concepts that were already described by Olivia also applies in Lithuania. However, there are some certain specifics to keep in mind. So first of all, moral rights cannot be licensed in Lithuania, so this is something to keep in mind. And there are some certain interesting, I would say, specifics with regards to copyrights and employment relationship. So if it is not agreed in the employment contract, for example, so the law distinguishes between two types of work that is protected by copyright. So first of all, there are some usual works that are created by employees, and then there are computer programs. So if something is the protection is not described in the contract, so the rule that is established in the law is that the economic rights to a work that is created by an employee while performing work functions, which is an important condition, are assigned to the employer for 5 years. So if you do not agree in the contract that, for example, the economic rights are transferred to an employer, for example, for the whole validity of the economic rights to work, so the law says that it's for 5 years. When we are talking about the computer programs, so if it is not specified otherwise, the rights to a computer program created by an employee while performing work functions belong to the employer. So there's no term of the validity. It means that if you not agree otherwise, the rights to a computer program are assigned to an employer indefinitely. And what is also a bit different from what Olivia mentioned, Lithuanian law does not, and the Lithuanian courts do not assign self-employed persons the same status as the employees with regards to copyright creation. So for contracts and for self-employed persons or legal entities, general rules for copyright assignment and licensing apply. Basically, Lithuanian law sets out conditions for copyright assignment and licensing agreements. So it doesn't mean that if you do not include one of these conditions that the agreement is void or not valid. It's usually the thing that, well, it's better to include the conditions into your agreement than not to, because if you do not include such conditions, then the law has some presumptions that would apply. So, of course, if you are agreeing on transfer or licensing of copyrights, it has to be, the work of the title of the work, the type of work, the requirements of it should be mentioned. What is very interesting is that modes of use should also be listed and included, because if you do not include the modes of use that to what the copyrights are assigned, so then they're under the law, they're interpreted narrowly. What does it mean? So the law says that if the modes are not specified, so that like the scope of the transfer or license is only to what is necessary to achieve to the purpose for which the agreement between the parties was concluded. So it could be, and there are some already case law, that if modes of use are not described, so then only the use of only the use of some certain works can be granted. Also, exclusivity or non-exclusivity should also be mentioned. Territory. So if the agreement does not specify for which territory the copyrights are assigned or licensing is granted, so the protection is only granted in Lithuania. And also with regards to term, if the term for which rights are assigned is not specified, then either party may terminate the other party by notifying the contract by notifying the other party, writing 1 year in advance of the termination of the agreement. So, and there is also some remuneration in this resolution to be included. So, as also mentioned by Olivia, basically it is always better to agree on certain aspects with regards to copyrights assignment and licensing agreements than not to agree on them and not to include them in the contract, because law has some presumptions to be included, and that would apply if the certain conditions are not included in the agreement. So this is something that I wanted to outline with regards to copyright protection in Lithuania, and I would like to give the floor to my colleague Linda.
Hi everyone, I'm Linda from Latvia. So I will briefly tell you about some differences about Latvia, and then we will proceed with a very hot topic about AI and intellectual property. So in Latvia, everything is the same as in Estonia and Lithuania, as my colleagues explained, except you need to remember that transfer or licensing of economic rights in employment relationship under the law is not limited in time. So this is good news. If you have employment agreements and you have forgotten to insert clauses about intellectual property use and transfer, the law does help you. You are not in a totally bad situation. But please remember, if the person is not your employee and, for example, you hire a self-employed person and the agreement is silent with respect to what happens with intellectual property. For example, the person develops you a very expensive computer software and the contract is silent about what happens with this computer software, you might be limited in using it. So please do remember this. We see in practice this mistake still unfortunately happens a lot. And another thing in Latvia, if you have a license agreement, right? Great, you already have an agreement. If the license is not restricted as to time, then the license provider may terminate such license with a 6-month prior notice. If the license says that it is provided for an indefinite term, it still remains unclear whether this allows this termination with 6-month prior written notice. There's no case law in Latvia that answers that. So as a precaution, we usually put a very long term, like 150 years in the contracts for the relevant licenses, because this is the term when the copyrighted work can actually be protected, and plus a little bit more time. But then we can move on to artificial intelligence and intellectual property issues. So we are all now using or starting to use artificial intelligence tools. Also in Sorainen, we are dabbling into this thing. But as with new tools, there are some issues to keep in mind when you are using them. And in respect to intellectual property, there are actually several issues that the use of artificial intelligence tools in your company may raise. So, and you need to, and this is important for you if your company creates valuable intellectual property. For example, you provide services with software and you want to use artificial intelligence tools to create software. Or if, I don't know, your company creates digital marketing materials and you are using artificial intelligence tools to create these marketing materials, and then you later sell these marketing materials to your clients. These are just few examples. So what are the issues to keep in mind if you are using artificial intelligence tools? Well, the first question is, who owns copyrighted works created by artificial intelligence tools? Or more, it would be more correct to say, who owns works created by artificial intelligence tools? Under Latvian law, which is and also likely under the law of all European Union countries, the work is defined as a result of an author's creative activity. And the author is defined as a natural person. So if you read these definitions, you understand that artificial intelligence tool is not a natural person. And when I give a very short prompt to the artificial intelligence tool, I am not engaging in a very exhaustive creative activity. So the issue that this creates is that the result that artificial intelligence tool creates does not belong, for example, to your employee who has to create the work. And therefore, it cannot also be transferred to your company. For example, if you're using artificial intelligence tools to program, then it is possible that your company does not own copyrights to this program. So, of course, we should not stop using artificial intelligence tools for this reason, but this is something for you to keep in mind. If you are creating important intellectual property, please consider whether you should be using artificial intelligence tools for that. And good news is that in some countries, like the UK, the creations of artificial intelligence tools can be created by copyrights, but this is because it is specifically stated in their law. And for the moment in the EU, at least in Latvia and the Baltic countries, this question has not yet been resolved. Next issue is, can the result provided by artificial intelligence infringe third-party rights? The answer is yes. And here is something for you to keep in mind. For example, if you are uploading a copyright protected image and asking the artificial intelligence tool to change it, and you don't have the copyrights to this image, you can still infringe the copyrights also to this changed image, the result of it. Another thing that I have seen is that we sometimes ask artificial intelligence tools, create me an image of Brad Pitt eating a burger, then you want to put that image on a t-shirt and you want to sell it. There are countries that protect rights to own image. And if you do not have the permission of Brad Pitt to sell such t-shirts, you cannot do that. And if there are no such rights to protect the person's own image, the limitation can still occur under the realm of general data protection regulation. And lastly, there's a question of, can you use your copyrights by using AI? And here the answer is maybe. So for example, if you insert a computer code in the AI tool and ask the tool to code something to be added to that, you should check before that you should check what does the general terms and conditions for using the AI tool provide. Maybe similarly as in case of open source software, is what my colleague Sidas will tell you about, there is also a condition that whatever you insert in the AI tool, image, text, computers, software codes, that for all these things, you are granting the license by inserting them in the tool. So please keep in mind not to put sensitive information in the AI tool before you read the rules about what will further happen to this information. Okay, and lastly, what to do. As I said, you don't need to stop using the AI tool. Even if there are these few issues you need to keep in mind, just be aware of these risks. Consider what are you asking your AI tool to do. Review contracts with artificial intelligence tool providers. All those tools that are free of charge usually have contracts that allow them to do the things that you put in the tool. Everything they are allowed to do everything with the things that you put into the tool. But if you are using a personalized tool, there the contracts may be more favorable for you and your business. And also consider implementing guidelines in the company when artificial intelligence tools can be used. For example, you can say you can use the tools for drafting marketing materials because we don't care if we own them or not, but maybe not use the tool for very important software programming. And that's it. Thank you for your time. And now I'm giving the floor back to Mihkel, who will introduce you to the next speaker.
Thank you very much. Interesting topics. And yes, we are moving on. My good colleague Sidas from our Lithuanian office is ready and will be speaking about open source components and their licenses, how to navigate them if you're using these in your computer programs. So Sidas, please.
I hope you can hear and see me. And I hope you can see the slides. Since we are a little behind the schedule, I will be quick and also because some of these points have already been touched by my colleagues. But nevertheless, I will be speaking about IP in computer programs. I will cover again, remind you what are computer programs, how are they protected, and what you should keep in mind when you or your business is using open source software. So according to the law, computer programs are protected as literary works. This part is harmonized in the EU, so essentially this would apply in Lithuania, Latvia, Estonia, and probably in all of the other member states. Some countries, for example, Lithuania, provide an additional definition of what is considered software or a computer program. And for example, Lithuanian law describes computer programs as a set of instructions expressed in words, code schemes, or in any other form capable, when incorporated in a computer-readable medium, of causing a computer to perform a particular task. What's important to note here is that computer software is protected not as an IP is protected not only the source code or the object code, but also preparatory or design material, if that preparatory and design material could be used to create the software. What is protected as a computer program? It's the expression of the computer program. In principle, this means that the code itself or the specific design material that is in objective form is protected. The other criteria for being granted protection is that the work should be original, and that's it. There are no other criteria of protection. For example, the code does not have to be good, the code does not have to be useful, and it does not necessarily even have to be usable in business and so on. This for example is difference from maybe patent law, where patents generally need to have some kind of industrial applicability. This is not this is not the case for computer programs. What is not protected as a computer program, and this was already mentioned by my colleagues, these are ideas and principles which underlie any element of a computer program. Basically, if you develop a software that does something, for example, moves data from database A to database B and aggregates it in some specific way, this specific element, this idea is not protected itself. Only the code that does that specific task is protected. What is also not protected as a computer software are additional elements. For example, graphic user interface. This specific exception comes from EU directives, but this has already been covered by courts, specifically Court of Justice of the European Union, where they said that the graphic user interface is not protected as software because it is just one element that allows use of features of that program, but does not allow reproduction of that program. However, graphic user interface or any other such auxiliary elements of software can be protected as other objects, generally as objects of copyright. So maybe if the graphic user interface is it can be protected as an artistic work, for example. Now, how to use software lawfully, and these are in principle the most common legal basis that you can rely on when using software. One is ownership, meaning that you can use software if you own it. Specifically, if you own the economic rights to the software. How could you receive ownership of the software? Sometimes it's developing software internally. If a business, generally these are IT businesses that have employees who work with writing code, they develop software, and in that sense they have the ownership of the economic rights. Businesses may also hire these other companies to develop software for them and agree that the ownership of the economic rights will be transferred. Businesses may also purchase already developed software from someone else if they see something that they like. Another option is licensing, which is essentially receiving the right to use the software, but not the ownership of the software. This would mean that you probably would not be able to resell the software to anyone else. You would be limited, perhaps in some ways of modification of the software and so on. But depending on the software licensing terms, you would be able to use it in your business. This could be, for example, based on bespoke agreements for specific software. Generally, these are relevant for bigger businesses, for more specialized businesses who purchase licensing rights to some specific software or its modules. This could be general off-the-shelf software that is subject to a single payment. Most of us use these Windows is that. There are software as a service products which generally involve periodic payments and access of the software via internet, via cloud. And there are also free of charge software which you can use without payment. And this is an important difference from open source in the sense that free of charge software is not necessarily open source, in the sense that free of charge software may have licensing rights that are very limiting, that maybe limit the use of the software and only allow you to use the software in certain ways, even if it's not subject to any payment. And last legal basis is using of software that is licensed under open source licenses. Open source in and of itself is not regulated as such as a separate category. Open source is essentially an umbrella that covers software that people share with others for open use. There are different kinds of open source licenses, for example, MIT, GPL, BSD, Apache. These are all names of most used open source licenses and licensing terms. And moving on with the open source, there are two main categories that we can group open source licenses into. One is permissive licenses, which cover open source software subject to licensing terms that allow essentially to do anything with the software. Specifically, permissive licenses are generally grouped in this area because they allow users of the software to make modifications to the software and then freely use the derivatives that have been created. For example, if you took a open source software, then made modifications to the software, you could sell it as proprietary software. You could license it for money. You could essentially commercialize the software. The other group are restrictive licenses, also called copyleft licenses, which are also open source licenses, but they limit commercialization of the software in the sense that if you make any modifications to the code, you have to distribute those modifications under the same license or under a compatible license for everyone else. Meaning that if you took a code that is subject to a copyleft license, made modifications, and then wanted to sell it to others, you couldn't do that because that would mean that you are infringing the relevant open source license. To summarize, we have two separate categories, which are permissive licenses and restrictive licenses. Permissive licenses allow to do anything or nearly anything with the code. And some examples of permissive licenses are MIT, BSD, Apache, whereas restrictive licenses can be used essentially freely, but any derivatives, any modifications must be licensed under the same license. And therefore, marketing of these derivatives and modifications is very difficult. For businesses, this means that if you want to make a proprietary product and you want to sell it to others, you want to license it to others and make money from that product, you should avoid copyleft licenses. If you want to use software which is subject to copyleft licenses, this should be used for internal collaborative software, for software that maybe you are not going to invest into when modifying the software and similar. Yeah, that's it from me.
Thank you, Sidas. We actually have one question that arrived at the time you were presenting, and in particular, it relates to this criteria that to protect the software, it has to be an original work. And the question is that how to assess whether a particular piece of software is an original work. And then the typical example is that a company has a former employee who has left the company and claims to have built some sort of new software and claims that now the former employer is illegally using the software. And then how are these sorts of disputes usually solved, and then with what outcome?
I guess we can all discuss this, but there is not much case law, at least in Lithuania, on this matter, and I guess this is not so much a legal question as it is a technical question for coding specialists. How would you assess it? You would basically look at the two different pieces of code and compare them. In case of a dispute, this would mean, as with any dispute, one side would try to prove that the code has been copied, and the other would try to prove that no, this is clearly different from your code. And for example, small excerpts of the code that could be identical are do not necessarily mean that you have copied the code in its entirety. And yeah, it's basically a burden of proof on each party to prove that the code is there.
All right, thank you, Sidas. We are now moving on to the Q&A session. We do have some questions to the other presenters as well, and I'll perhaps start with Helery. Just perhaps you can give advice in a hypothetical situation, like where let's say an organization is not sold that they need to have an audit. What is this one thing that they should, in your opinion, still do or put their focus on if they don't want to do the full audit right away? Any thoughts?
Yeah, thank you. Well, first I would say, like, I don't know, just as with workout and diet, start now. Basically, the next agreement that you're going to make, at least think about the right licensing agreements and the things that are important for you. So even if you don't want to dig out all the skeletons from the past, like the next thing that you do, maybe think further and think about the compliance. But more importantly, if you can just focus your attention then to the most important aspect that your business has, so whether it be the software or a kick-ass branding name, let's just fix this then, even if you don't want to come up with all the audit things right away.
All right, thank you. We do have time for a few more questions, so maybe I'll ask from Linda a similar kind of question about this AI and use of AI tools within an organization to create new, let's say, works or components. So what would be your most important recommendation to I don't know, compliance officers of organizations or heads of legal? What is it that they should really focus on when they know that their organization is using AI tools in their everyday business?
Well, it's this first step to assess what you are using it for, and to create some guidelines not to use it for intellectual property that is very material to the business, because this question about whom owns this intellectual property created by the artificial intelligence tool is either unclear, or it is clear that it does not belong to the author. And if it does not belong to the author cannot contractually transfer these rights to this intellectual property to the company, and therefore the company does not anymore own valuable intellectual property that it uses to provide services to clients or licenses it further. So I think it's basically carry out an IP audit. This is the main thing. Understand what intellectual property do you create as part of your business, and whether and how you use the AI tools, and then you can determine if it is okay to use them, because it doesn't matter if you don't own it, or if you should maybe not use them, or if you should buy some, or if you should not use them. That's it.
All right, thank you. Sidas, we have one more question for you. And this relates to copyleft type of licensing. Our guests are asking if they understood correctly that copyleft software cannot be sold or commercialized, even if if they are using the same license. For example, if there is a component in the software that is licensed under GPL and I have licensed the software under GPL2, can I still sell the software licensed under GPL?
All copyleft licenses are not the same, so we need to look at each specific license that is relevant. But the grouping of copyleft licenses means that basically copyleft licenses require you to, if you make any modifications to the software, to the code that you used, that you took from the relevant depository, if it says that, and copyleft licenses usually say that you need to distribute the code and any modifications made to the code under the same conditions that the original code was published in. So that would mean that if you were able to use the code yourself freely and to modify it and so on, then you have yourself the obligation to publish it and allow others to freely use the code under the same conditions. This would mean that selling this as a proprietary product would probably infringe the original copyleft license.
Right. Thank you very much, Sidas. And since we are running out of time, this was the last question we can take. If you have any questions that remain, or you feel that you want to brainstorm some burning IP issues with our specialists, you will shortly see on your screens the contact details, key contacts from all Baltic countries, Olivia in Estonia, Linda in Latvia, and Sidas in Lithuania. Thank you very much for attending today. We hope you found this webinar to be useful, and as mentioned in the beginning, the recording will also be distributed in a few days' time. Thank you very much and see you soon.